Hi, my name is Dan Stone. I'm an associate in the Trust, Estate, and Elder Law Department at Mandelbaum Barrett. And today I'm going to talk about estate planning tips for people in their 20s and 30s, particularly newly married couples and people who are considering starting a family. Estate planning can seem like the kind of thing that you only think about later in life, but really it's never too early to start, particularly when you're starting this next chapter of your life as a married couple. In most cases, married couples leave their assets to the surviving spouse, or if that spouse predeceases them, to their children. An important consideration that can be incorporated into any will, particularly for a newly married couple, is the appointment of a guardian. In the event that both spouses pass away, appointing a guardian can ensure that the person that raises your child is someone who's clearly up for the task and who you know has your child's best interest at heart. A will also appoints an executor. Typically, it's their surviving spouse, who's the person responsible for administering the estate, ensuring taxes are paid, and coordinating with all of the beneficiaries. In the context of a marriage, where you have families coming together for the first time, it's important to appoint these fiduciaries ahead of time so that you do not have a family member who you're not so familiar with assuming a fiduciary role in your estate. Another important aspect of any will for a newly married couple is the establishment of a minor's trust. The trust will hold any inheritance that your child receives and will only be distributed to that child at an age you select. The trustee that you designate will be responsible for managing those funds and using them for the child's support, education, and living expenses. If you have a child with special needs, you can also establish a special needs trust, which similarly will reserve funds for that child's support, welfare, education, and living expenses. Importantly, those funds will not be counted against them in the event that that child requires government benefits like Medicaid. Another effective tool for planning for your child's future is a 529 plan. A 529 plan is a tax advantage investment plan geared towards your child's higher education. These accounts can cover tuition, room and board, supplies, and even a laptop. Like a Roth 401k or a Roth IRA, contributions to a 529 plan are made with after-tax dollars and grow tax-free. Very important consideration that's often overlooked is that not all assets pass through your estate. Life insurance policies, retirement plans, accounts with beneficiary designations pass in accordance with the named beneficiary, regardless of what's said in the will. So, if you decide to establish a new will, it's important to make sure that the beneficiary designations mirror the will. For couples that sign prenuptial agreements, many prenuptial agreements require that one spouse maintain a life insurance policy for the other. So to the extent that you change your beneficiary designations, you want to make sure that it's in accordance with the term of that pre-established prenuptial agreement. Another critical aspect of any estate plan is appointing fiduciaries to make decisions in the event that you're unable to yourself. We do this through a power of attorney and a living will. A power of attorney is a document that designates an agent to make legal, personal, or financial decisions on behalf of someone else. Generally, spouses will appoint each other as their agent under power of attorney. There are two different kinds of powers of attorney: durable power of attorney and what's called a springing power of attorney. A durable power of attorney is effective immediately upon signing. A springing power of attorney, however, springs into effect only upon one of the spouse's incapacity. And this is proven usually by a doctor's certification. Typically, if an agent under a springing power of attorney needs to act, is because of some emergent matter that needs to be attended to. So the requirement that that spouse then obtain a doctor's certification can delay the process, and in that sense may not be appropriate or ideal. Another important document is what's called a living will, which, like a power of attorney, appoints an agent to act on behalf of someone else. The difference is that a living will only applies to medical decision making. A living will consists of two main parts, an advance directive and a healthcare proxy. An advance directive outlines a person's wishes as to life-sustaining treatment in the event that they have an irreversible or terminal illness. A healthcare proxy is simply the person designated to make legal decisions on someone else's behalf, usually, again, the spouse. Having these documents in place avoids confusion and ensures that your family will not have to make a difficult decision on your behalf without knowing what you would have wanted. Estate planning is about avoiding issues before they occur and making sure that your wishes are clear, legally protected, and easy to follow by your family when the time comes. If you're just married or thinking about starting a new family, it's simply never too early to consider your first estate plan. If you have any questions, myself and my team at Mandelbaum Barrett are here to help. Thank you for listening.